Today, we bring forward formal criminal charges, charges not brought by political insiders, charges not dependent on whether a prosecutor feels like doing their job, charges sworn under penalty of perjury by a private citizen and now publicly entered into the historical record. In Minnesota, a criminal complaint signed by a private citizen needs only one more step to proceed: a prosecutor's signature. Without it, these charges stall. Without it, justice is delayed and perhaps denied. I have submitted these criminal complaints to the Pine County Attorney's Office. I have filed oversight complaints with state regulatory bodies. I have attempted to submit these charges to the Attorney General of Minnesota, and I am actively requesting time on Governor Walz's calendar to demand that he intervene, appointing the Attorney General directly if Pine County officials continue to obstruct accountability. Today, I will read these charges aloud, page by page. Each complaint will be displayed as I read it. You will hear every accusation, every count, every line of probable cause. You will see for yourself what has been filed and what Pine County hopes you never hear. At the conclusion of this reading, I will issue a formal call to action. This fight belongs to all of us. This fight belongs to the Constitution. This fight belongs to the people. Justice demands action. In the matter of the state of Minnesota versus Deputy Carl Hawkinson, badge number 544, Pine County Sheriff's Office. The following charges have been formally alleged under oath and under penalty of perjury. Count 1. Conspiracy to commit retaliation against constitutionally protected activity. Minnesota statutes, paragraph 60.175. Maximum sentence, 5 years imprisonment and or a $10,000 fine. Count 2. Retaliation against whistleblower. Minnesota statutes, paragraph 609.498, subdivision 1, subdivision F. Maximum sentence, 5 years imprisonment and or a $10,000 fine. Count 3. Unlawful detention, false imprisonment. Minnesota statutes, paragraph 609.255. Maximum sentence, 1 year imprisonment and or a $3,000 fine. Count 4, filing a false petition for harassment restraining order. Minnesota statutes, paragraph 609.505. Maximum sentence, 1 year imprisonment and or a $3,000 fine. Count 5, misconduct of a public officer, general abuse of authority. Minnesota statutes, paragraph 609.3, subdivision 1. Maximum sentence, 1 year imprisonment and or a $3,000 fine. Count 6, misconduct of a public officer, failure to perform mandatory duty. Minnesota statutes, paragraph 609.43, subdivision 2. Maximum sentence, 1 year imprisonment and or a $3,000 fine. Oppression under color of law. Minnesota statutes, paragraph 609.43, subdivision 3. Maximum sentence, 1 year imprisonment and or a $3,000 fine. Count 8, assault in the 5th degree, intent to cause fear of bodily harm. Minnesota statutes, paragraph 609.224, subdivision 1, subdivision 1. Maximum sentence, 90 days imprisonment and or a $1,000 fine. Statement of probable cause. On January 14th, 2022, Deputy Carl Hawkinson, while acting under color of law as a licensed peace officer with the Pine County Sheriff's Office, unlawfully detained the complainant without reasonable articulable suspicion or probable cause. At the time of the incident, the complainant was lawfully engaged in public recording of a marked squad car, parked in a public location. During this activity, Deputy Hawkinson positioned himself at the complainant's 5 o'clock just outside of the complainant's peripheral vision and issued verbal commands ordering the complainant not to record the contents of his squad computer screen. Moments later, Deputy Hawkinson lunged toward the complainant's hand in an apparent attempt to seize the recording device. The complainant instinctively recoiled, experiencing an immediate and genuine fear response due to Deputy Hawkinson's armed status, aggressive movement, and position of lawful authority. Despite this aggressive conduct, video evidence confirms that Deputy Hawkinson made no attempt to enter his vehicle or shield the in-vehicle computer screen. Instead, he remained outside the vehicle, facing the complainant, issuing verbal commands focused on control and compliance, conduct inconsistent with any benign intent to secure sensitive data. Deputy Hawkinson has consistently maintained, both verbally during the incident and in subsequent legal filings, that his detention of the complainant was based on alleged violations of Minnesota's Data Privacy Act. However, the complainant asserts that this reliance was both factually and legally unfounded, as the complainant was lawfully recording from a public vantage point where no reasonable expectation of privacy existed, and where Minnesota law does not prohibit the recording of government employees or public data displayed in plain view. The complainant perceived this series of actions, the physical positioning, the verbal orders to suppress recording, the sudden lunge, and the absence of protective data measures, as an intentional intimidation tactic deployed for the purpose of asserting unlawful control, retaliating against protected speech, and chilling future exercise of constitutional rights. Following this detention, Deputy Hawkinson filed a harassment restraining order against the complainant. This filing occurred within weeks of the complainant engaging in lawful and constitutionally protected activity, including freedom of speech, peaceful assembly, and petitioning the government for a redress of grievances under the First Amendment. The filing proceeded through the Pine County District Court, with the Pine County Attorney's Office representing Deputy Hawkinson in his official capacity. In support of his harassment restraining order, Deputy Hawkinson cited actions of third parties, including comments posted online by individuals unknown to the complainant, a photograph of a middle finger sent by a third party, and calls made to Pine County Dispatch. The complainant asserts that these examples do not constitute harassment under Minnesota law, nor can they be lawfully attributed to the complainant. These incidents reflect public criticism and lawful expression by independent members of the public, not unlawful conduct by the complainant. Deputy Hawkinson's petition also referenced a video created by the complainant, in which the complainant hypothetically discussed this case with the chief of police in Cambridge, Minnesota, a lawful exercise of free speech and public discourse, and conduct wholly unrelated to Deputy Hawkinson or Pine County. The conditions of the harassment restraining order significantly restricted the complainant's ability to lawfully assemble, protest, or directly access the Pine County Sheriff's Office or courthouse without risk of violation. These restrictions had the immediate effect of suppressing the complainant's lawful and protected efforts to petition the government for accountability and redress. Furthermore, the complainant asserts that Deputy Hawkinson's conduct, including the unlawful detention without legal justification, misuse of the Minnesota Data Privacy Act, and the filing of a retaliatory harassment restraining order, constitutes a conspiracy to commit a crime, in violation of Minnesota statutes, paragraph 609.175. These acts were undertaken with knowing intent to suppress the complainant's constitutional rights, to retaliate against lawful and protected activity, and to abuse the processes of government authority for personal and retaliatory gain. The overt acts in furtherance of this conspiracy include the unlawful detention itself, the verbal commands to suppress lawful recording, and the knowingly false or misleading statements made within the harassment restraining order petition. Deputy Hawkinson's conduct constitutes a pattern of oppression, bad faith, retaliation, and abuse of governmental authority in violation of Minnesota law. Request for arrest warrant. Pursuant to Minnesota statutes, paragraph 629.42, the complainant respectfully requests that the court issue a warrant of arrest for Deputy Carl Hawkinson based upon the established probable cause. The complainant asserts that immediate arrest is necessary to prevent further harm, to ensure the defendant's appearance in court, and to uphold public trust in law enforcement accountability. Deputy Hawkinson's conduct, as detailed in the foregoing statement of probable cause, constitutes a pattern of unlawful acts, abuse of governmental authority, retaliation against protected speech, and interference with constitutionally protected rights, rising to a level that justifies the issuance of a warrant for his arrest. In the matter of the State of Minnesota versus Reese Fredrickson, County Attorney for Pine County, Minnesota, the following charges have been formally alleged under oath and under penalty of perjury. Count 1. Conspiracy to commit retaliation against constitutionally protected activity. Minnesota statutes, paragraph 609.175. Maximum sentence, 5 years imprisonment and/or a $10,000 fine. Count 2. Retaliation against complainant, Minnesota statutes, paragraph 609.498. Subdivision 1, subdivision F. Maximum sentence, 5 years imprisonment and/or a $10,000 fine. Count 3. Coercion, Minnesota statutes, paragraph 609.27, subdivision 1, subdivision 4. Maximum sentence, 5 years imprisonment and/or a $10,000 fine. Count 4. Misconduct of a public officer, breach of duty, Minnesota statutes, paragraph 609.43, subdivision 1. Maximum sentence, 1 year imprisonment and/or a $3,000 fine. Count 5. Oppression under color of law, Minnesota statutes, paragraph 609.43, subdivision 3. Maximum sentence, 1 year imprisonment and/or $3,000 fine. Count 6. Obstruction of legal process or investigation, Minnesota statutes, paragraph 609.500, subdivision 1, subdivision 1. Maximum sentence, 1 year imprisonment and/or a $3,000 fine. The full statement of probable cause as filed and sworn will now be read into the public record. Now reading Statement of Probable Cause, Reese Fredrickson. On or about January 14th, 2022, and continuing through 2023 in Pine County, Minnesota, Defendant Reese Fredrickson, while acting under color of law in his official capacity as county attorney, engaged in a deliberate and unlawful course of conduct constituting retaliation, coercion, conspiracy, and misconduct against the complainant, Travis Martin Larson. At all relevant times, the complainant was engaged in constitutionally protected activities, including lawful protest, public criticism of government officials, and the filing of good faith complaints regarding misconduct by Deputy Carl Hawkinson. Rather than uphold his sworn duty to enforce the law without fear or favor, Defendant Fredrickson willfully abused the power of his office to retaliate against the complainant and obstruct lawful accountability processes. The misconduct of Defendant Fredrickson included, but was not limited to, authoring and transmitting a threatening letter to the complainant on January 24th, 2022 for the unlawful purpose of intimidating the complainant into silence and chilling further exercise of constitutional rights. Said letter falsely accused the complainant of committing crimes and warned of potential civil liability, despite the complainant's lawful activities being fully protected by the First Amendment. Participating in, endorsing and advancing the misuse of the harassment restraining order process initiated by Deputy Hawkinson, despite having knowledge that the complainant's conduct did not meet the statutory definition of harassment under Minnesota law. Improperly and unlawfully using the resources of the Pine County Attorney's Office to represent Deputy Carl Hawkinson's personal retaliatory petition for a harassment restraining order against the complainant. This misuse of public authority to pursue a private retaliatory objective constitutes an overt act in furtherance of a conspiracy to suppress constitutionally protected speech and a flagrant breach of the county attorney's sworn duty to serve the public interest rather than individual employees. Refusing to investigate credible allegations of unlawful detention, assault, and retaliation by Deputy Hawkinson, despite receiving formal complaints and video evidence from the complainant. Colluding with members of the Pine County Sheriff's Office to shield Deputy Hawkinson from accountability and to target the complainant for retaliatory treatment. Accessing, using, or tolerating the use of the complainant's private address information without maintaining or producing any lawful data access records as required under Minnesota law, thereby weaponizing government-held information against a private citizen without legitimate purpose. selectively enforcing criminal statutes and misusing prosecutorial discretion to retaliate against a complainant who is lawfully exercising First Amendment rights, thereby oppressing the complainant under color of law. These acts constitute criminal retaliation against a complainant under Minnesota statutes, paragraph 609.498. Coercion under Minnesota statutes, paragraph 609.27. Conspiracy under Minnesota statutes, paragraph 609.175. Misconduct of a public officer under Minnesota statutes, paragraph 609.43. Oppression under Minnesota statutes, paragraph 609.43, subdivision 3. And obstruction of legal process under Minnesota statutes, paragraph 609.50. Further, the complainant asserts that Defendant Fredrickson's conduct, when viewed cumulatively, rises to the level of a criminal conspiracy to suppress constitutional rights, using official power and resources to silence dissent and obstruct redress of grievances. This pattern of misconduct reflects not an isolated error, but a deliberate campaign by a public official entrusted with prosecutorial discretion, a campaign that unlawfully targeted, threatened, and retaliated against a private citizen for exercising rights protected by the United States Constitution and the Minnesota Constitution. Accordingly, probable cause exists to believe that Defendant Reese Fredrickson committed the offenses charged herein. Request for arrest warrant. Pursuant to Minnesota statutes, paragraph 629.42, the complainant respectfully requests that the court issue a warrant for the arrest of Defendant Reese Fredrickson based upon the established probable cause. Immediate arrest is necessary to prevent further harm, ensure the defendant's appearance in court, and uphold public trust in government accountability. In the matter of the State of Minnesota versus Jeff Nelson, Sheriff of Pine County, Minnesota, the following charges have been formally alleged, under oath and under penalty of perjury. Count 1. Conspiracy to commit retaliation against constitutionally protected activity. Minnesota statutes, paragraph 609.175. Maximum sentence, 5 years imprisonment, and/or a $10,000 fine. Count 2. Misconduct of a public officer, failure to perform mandatory duty. Minnesota statutes, paragraph 609.43, subdivision 2. Maximum sentence, 1 year imprisonment, and/or a $3,000 fine. Count 3. Misconduct of a public officer, breach of public trust, Minnesota statutes, paragraph 609.43, subdivision 1. Maximum sentence, 1 year imprisonment, and/or a $3,000 fine. Count 4. Liability for crimes of another, enabling retaliation, falsification, and obstruction. Minnesota statutes, paragraph 609.05. Maximum sentence, same penalties as for the underlying crimes. Count 5. Obstruction of legal process or official investigation. Minnesota statutes, paragraph 609.50, subdivision 1, subdivision 1. Maximum sentence, 1 year imprisonment, and/or a $3,000 fine. The full statement of probable cause as filed and sworn will now be read into the public record. Now reading. Statement of probable cause, Jeff Nelson. On or about January 14, 2022, and continuing through 2025, in Pine County, Minnesota, Defendant Jeff Nelson, while acting under color of law in his official capacity as sheriff, engaged in a deliberate and unlawful course of conduct constituting conspiracy, retaliation, obstruction, and gross misconduct against the complainant, Travis Martin Larson. At all relevant times, the complainant was engaged in constitutionally protected activities, including peaceful protest, public criticism of government officials, and the filing of good faith grievances regarding the unlawful detention and retaliation committed by Deputy Carl Hawkinson. Rather than uphold his sworn duty to ensure the integrity of law enforcement and protect the constitutional rights of citizens, Defendant Nelson willfully abused the power of his office to obstruct accountability, enable misconduct by subordinates, and retaliate against the complainant. Defendant Nelson's misconduct included but was not limited to refusing to investigate credible allegations of unlawful detention and constitutional violations committed by Deputy Carl Hawkinson, despite receiving formal complaints, video evidence, and supporting documentation. Personally reviewing and printing altered incident reports associated with the unlawful detention and retaliation, while failing to take corrective action or initiate proper investigative procedures. Allowing, authorizing, or tolerating multiple post-event modifications of official incident reports after lawful public data requests had been filed, including the injection of redacted and sanitized documents intended to obstruct public review and conceal official misconduct. Failing to preserve the integrity of government records once public data requests were active, as required by Minnesota statutes, Chapter 13, the Government Data Practices Act, and thereby enabling and ratifying material falsifications of public documents. Acting in concert with other Pine County Sheriff's Office employees, including Deputy Carl Hawkinson, Julie Mazer, Katie Beck, and Joshua Matson, in furtherance of a conspiracy to suppress the complainant's First Amendment activity and obstruct redress. Willfully permitting repeated document tampering and narrative manipulation within Pine County's official records management system after grievances were known to be pending, thereby participating in a coordinated campaign of retaliation and obstruction under color of law. These acts constitute criminal conspiracy under Minnesota statutes, paragraph 609.175, misconduct of a public officer under Minnesota statutes, paragraph 609.43, obstruction of legal process under Minnesota statutes, paragraph 609.50, and supervisory liability for crimes committed by others under Minnesota statutes, paragraph 609.05. Further, the cumulative actions of Defendant Nelson demonstrate a pattern of deliberate indifference to constitutional rights, gross violation of sworn public duties, and conscious participation in the obstruction of legal process for personal or institutional protection. Accordingly, probable cause exists to believe that Defendant Jeff Nelson committed the offenses charged herein. Request for arrest warrant. Pursuant to Minnesota statutes, paragraph 629.42, the complainant respectfully requests that the court issue a warrant of arrest for Defendant Jeff Nelson based upon the established probable cause. Immediate arrest is necessary to prevent further harm, ensure the defendant's appearance in court, and uphold public trust in law enforcement accountability. The time for silence has ended. The time for excuses has ended. The time for accountability has arrived. Formal criminal complaints have been filed against Deputy Carl Hawkinson, County Attorney Reese Fredrickson, and Sheriff Jeff Nelson. They have been submitted to the Pine County Attorney's Office. They have been submitted to state oversight agencies. They have been submitted to the United States Department of Justice. A direct request for action has been made to the Attorney General of Minnesota, and a formal request has been submitted to Governor Tim Walz for intervention to appoint a special prosecutor if Pine County refuses to act. Now it is time for you, the public, to act as well. Contact the Pine County Attorney's Office. Demand immediate prosecution or the appointment of a special prosecutor. Contact the Pine County Administrator's Office. Demand answers. Demand accountability. Demand public transparency. Contact the Minnesota Attorney General's Office. Demand that they accept jurisdiction if local officials refuse to fulfill their oath of office. Share this story. Tell your friends. Tell your neighbors. Tell your representatives. This is no longer a complaint. This is no longer a grievance. This is no longer a request. This is a formal notice. The people are watching, and history will record who stood and who stayed silent. This fight belongs to all of us. This fight belongs to the Constitution. This fight belongs to the people.